Good afternoon. I'm Dick Danner. I'm the Senior Associate Dean for Information Services and Research Professor of Law. And I want to welcome you to today's program, which is sponsored by our program in public law with lunch provided by the Information Services departments. I also want to make sure you're aware that the library has mounted what I think is a fairly interesting display right inside the entrance in the display case about the events that we're going to be discussing today. So you may want to take a look at that if you have a chance to pass by there. We're gathering here today to mark the gift of what I think we feel is an important document to the law library and to the university. In President Richard Nixon's letter of July 23rd, 1973 to Judge John J. Sirica of the District of Columbia District Court, as you'll hear and see, the president refused to turn over to the grand jury investigating the Watergate break-in recordings of White House conversations that were thought likely to be relevant to that investigation. And when he wrote his letter to Judge Sirica with copy to the special investigator Archibald Cox, President Nixon invoked the principle of executive privilege as the reason for not turning over those tapes. And his answer eventually led to the Supreme Court decision in U.S. versus Nixon. The letter is significant both for its connection to that case, its historical and its legal significance, but also for us because, as I'm sure you know, President Nixon is a 1937 graduate of this law school. The issues that are raised in the letter remain important and of interest to us today, as we've seen even during the past few months with the revelation in May of the identity of Deep Throat, the long, mysterious source of information about the Watergate break-in, who leaked information to the Washington Post about the break-in at the time. And also because, as I'm sure you're aware, the executive privilege was cited as one of the reasons for the withdrawal of White House counsel Harriet Miyer's nomination to the Supreme Court in October. So these remain relevant and interesting issues. Our speakers today are Chris Schroeder, who's the Charles S. Murphy Professor of Law and a director of the program in public law here in the law school, who will speak about the continuing significance of the issues raised in the confrontation between Judge Sirica and President Nixon and the case of U.S. versus Nixon. And also, we're very pleased to have with us today John J. Sirica Jr., or Jack Sirica, who is a noted journalist who is presently a deputy editor in charge of investigations at Newsday, who will talk about his father's role in the controversy. Jack is himself a graduate of Duke University. When he visited us earlier this year to talk about the donation of the letter, he was accompanied by his daughter Amalia, who we expect to be entering Duke as an undergraduate in 2007. And today he's here with his son Jackson, who is seated in the audience, and we're pleased to have both of them with us today. After both speakers have made their remarks, we'll take some questions, and then we will conclude with Mr. Sirica making official the gift of the letter to the university with Dean Bartlett. So, with no further to say, Chris.
Thank you, Dick. I'm going to use a few visual aids here today. All right, let me take you back to the summer of 1973, which was a typically hot and steamy day in Washington, a town built on ground that used to be a swamp, and some contend that the city still resembles one. 7 relatively low-level operatives of the committee to re-elect the president had been caught the previous year breaking into the Watergate headquarters of the Democratic National Committee. All of them had been convicted earlier in the year after a trial presided over by Judge John Sirica. But leading up to that summer, there was a feeling throughout the city that there was more to find out about the break-in. After a pre-sentencing bond hearing following the conviction of the folks who came to be known as the Watergate plumbers, or the White House plumbers, Judge Sirica had said in open court, "I have not been satisfied, and I am still not satisfied, that all the pertinent facts that might be available," I say might be available, "have been produced before an American jury." And in fact, the investigation had only gotten hotter and more intense after the convictions, getting a jump start when one of the plumbers, James McCord, belatedly decided to cooperate with the prosecution. Attention was focusing more and more on a search for an answer to the question that Senator Howard Baker posed during the hearings held by the Senate Select Committee. What did the president know, and when did he know it? The Senate committee, chaired by North Carolina's Sam Ervin, was running its own investigation in parallel with the efforts of federal prosecutors and the grand jury, and that effort had raised the temperature in Washington further when John Dean came forward and indicated that the president had knowledge of the break-in and was engaged in a subsequent cover-up. The final chapter of the Watergate story, of course, would come a year later with the resignation of President Nixon in August of 1974, as the House of Representatives sat posed to vote articles of impeachment against him. While that final chapter may be the one most easily brought to mind, for public lawyers, the most riveting aspects of the Watergate investigation involved the constitutional confrontation between the president, the courts, and the Congress that had preceded it. As the Watergate investigation and the eventual impeachment of the president unfolded, there were a number of specific events so memorable that they made an impression on people who were aware of them at the time, similar to that made by the assassination of John F. Kennedy or Martin Luther King, or the announcement of the O.J. Simpson trial, or the collapse of the Twin Towers and the World Trade Center. People old enough to be aware of those events as they happened can remember exactly where they were and what they were doing when they learned about them. In the case of the Watergate investigation, one of those moments was certainly when an obscure White House employee, Alexander Butterfield, testified before the Senate Select Committee on July 16, 1973, that the White House had a taping system. By the time Butterfield made his stunning announcement, Nixon's key aides, Bob Haldeman and John Ehrlichman, had already resigned, as had Attorney General Kleindienst. Kleindienst was replaced by Elliot Richardson, and the focus of the investigation on higher-ups of the White House then pressured the president into appointing a special prosecutor, Archibald Cox. So the situation was already tense when Butterfield testified. The Newsweek cover showing the White House in the form of a tape recorder, that there was a taping system in which recorded conversations from the Oval Office may still exist. So the investigation began really honing in on the question of what the president knew and when he knew it. And the special prosecutor, Archibald Cox, who had been on the job for just a couple of months, had gone to the grand jury and within days obtained from Judge Sirica a grand jury subpoena asking the president to turn over the tape recordings of particular conversations in the Oval Office. On July 25, 1973, President Nixon signed a personal letter to Judge Sirica declining to produce the tapes and other documents called for by the subpoena. This is the letter that Duke Law School is honored to receive and accept as a gift from Jack Sirica today, Judge Sirica's son. The letter was followed in court by a special appearance of President Nixon's lawyer, James St. Clair, who, for the record, declined to produce the requested tapes and moved to quash the subpoena. Now, a special appearance, for those of you whose rules of civil procedure are a little hazy, is an appearance entered by a lawyer for a client when the party intends to contest jurisdiction of the court over the matter. And that's precisely what the president's lawyers did. The predicate for such a challenge had been laid out very plainly in the July 25th letter, when President Nixon wrote, I must decline to obey the command of that subpoena. In so doing, I follow the example of a long line of my predecessors who have consistently adhered to the position that the president is not subject to compulsory process from the courts. A necessary implication of this view was that the president occupies a unique position in our constitutional system, insofar as it remains a matter of the president's own good judgment whether or not he would choose to follow an order of any court. Because this was the president's stand, throughout the tape controversy, there was always a question lurking in the background. Suppose the Supreme Court, the highest court in the land, ordered the president to produce the tapes. Would he in fact do so? Or would we in fact instead be faced with the dilemma of what to do if the president refused? These questions would later become one of the grounds of discussion for articles of impeachment that would be drawn up in the House of Representatives. But for now, and actually throughout this entire following year, the critical issues were being driven by actions taken in a single federal courtroom by John Sirica, a federal judge who reached conclusions that disagreed with the president and who had the courage to stick to those convictions. As for the president, his letter stated that he must respectfully and reluctantly decline to comply with the subpoena. Communications between himself and his aides, he wrote, are privileged communications. It would be inconsistent with the constitutional position of the presidency to make available recordings of meetings and telephone conversations in which I was a participant. We recognize this today, of course, as a claim of executive privilege, one which the president claimed at the time to be absolute. Well, Judge Sirica issued a ruling denying the president's motion, and that ruling went up to the Court of Appeals. On October 12th, that court upheld Judge Sirica's order, and the following week, the Nixon administration attempted to negotiate a deal with Archibald Cox, whereby they offered to have Democratic Senator John Stennis of Mississippi listen to the tapes and write summaries of them for Cox. Stennis at the time was notoriously hard of hearing. This is a well-known fact around town. If you've listened to any of these tapes, you understand how close to unintelligible many of them are. Nixon's deal, an obvious attempt to circumvent the appellate court's ruling, was unacceptable to Archie Cox, and he said as much in a press conference on October 19th. The next day, Saturday, Nixon ordered Elliot Richardson to fire Cox. Now, during his confirmation hearings, Attorney General Richardson had personally promised the committee that Cox would have full independence, and he concluded that he must resign rather than follow the president's order. The Deputy Attorney General, William Ruckelshaus, then also refused to comply with the president's order and resigned. Finally, Robert Bork, Solicitor General at the time and third in command at the Justice Department, carried out the instructions. The events of the day soon became known as the Saturday Night Massacre. Nixon's actions shocked the nation, but they were fully in keeping with the theory of the office of the presidency that lay behind President Nixon's letter to Judge Sirica, and that in Nixon's mind fully justified his actions. Although at the time we had not produced this label for the theory, we can recognize it as the theory of the unitary executive. The belief that all the powers of the executive branch are irrevocably held by the president alone, and that any delegations of those authorities to subordinate officers occur only at the sufferance of the president, who is capable of exercising them at any time. Thus, when President Nixon told the special prosecutor that he should accept the offer of Senator Stennis listening to the tapes, he was speaking as a superior to a subordinate, and a subordinate who had no choice but to obey the instruction. When Cox saw things differently, the natural consequence was to replace him with someone else. However much Cox's firing comported with President Nixon's theory of the presidency, it failed utterly to quiet public opinion. And in the inflamed aftermath of the massacre, Nixon, in fact, released all the tapes sought in the original subpoena, voluntarily, of course, and also accepted the appointment of a new special prosecutor, Leon Jaworski. The president, however, had by no means abandoned the view of the presidency put forth in his letter to Judge Sirica. In his mind, he had not acknowledged the authority of the court, but rather had made an independent judgment regarding his best course of action under the circumstances. He soon had the opportunity to express this view again because both the Senate committee and Jaworski requested even more tapes. This time, the president thought it inexpedient to fire Jaworski and instead instructed his lawyers to litigate. Judge Sirica issued a second subpoena on April 30, 1974, and once again rejected Mr. St. Clair's arguments. In an extraordinary move, the Supreme Court granted certiorari directly from this order before judgment in the Court of Appeals in order to render a definitive ruling as expeditiously as possible. By July 1974, the parties had briefed the case, and the Supreme Court was sitting in an extraordinary summer session to hear just this one case, allowing each side 1.5 hours of argument. I want to play you just a few minutes of this argument in closing so that you can hear from Mr. St. Clair and the justices just a small sense of the arguments set forth in the letter made before the court and the court's reaction to them. This first excerpt involves Justice Thurgood Marshall, who's having a great deal of difficulty with the president's claim that the court lacked jurisdiction to order the president to turn over the tapes, and his questioning of Mr. St. Clair is relatively sharp.
You're submitting the matter to this court.
To this court under a special appearance on behalf of the president.
You're still leaving it up to this court to decide it.
Well, yes, in a sense.
Yes.
In a sense.
No, well, in what sense?
In the sense that this court has an obligation to determine the law. All right? The president also has an obligation to carry out his constitutional function.
For us to decide whether or not executive privilege is available in this case.
Well, probably the question is even more limited than that. Is the executive privilege, which my brother concedes, absolute, or is it only conditional?
I said in this case. Can you make it any narrower than that?
No, sir.
Well, do you agree that that's what's before this court and you're submitting it to this court for decision?
This is being submitted to this court for its guidance and judgment with respect to the law. The president, on the other hand, has his obligations under the Constitution.
Are you submitting it to this court for this court's decision?
As to what the law is, yes.
So the careful wording of Mr. St. Clair will not have escaped your ears, I suspect. Once again, even before the Supreme Court, leaving open the possibility, at least in the president's mind at the time, that he might choose not to comply with the court's decision. The next, we have an exchange between Justice Potter Stewart, I believe it's Justice Potter Stewart, and Mr. St. Clair, in which the president's lawyer explains the unitary executive theory as it would have applied if there had been no special prosecutor, but simply a federal U.S. attorney prosecuting the case.
So a United States attorney brings the prosecution, and in the course of that prosecution, he, before trial, subpoenas under Rule 17 of the Federal Rules of Criminal Procedure. He subpoenas material in the custody of the president. So what happens?
The president says to the Attorney General, I'm not going to produce this material.
No, well, it's the United States attorney subpoenaing it under your hypothetical case.
That's right.
And so what happens?
And the president, in my view, the president would instruct the Attorney General to instruct the United States attorney to withdraw his motion.
And the United States attorney says, I'm not going to do that because
we'd have a new United States
attorney. I'm sworn to uphold justice. And, well, now how would you have a new United States attorney?
Well, I'm being a little facetious.
And I'm being serious because
I think that United States attorney, in all respects, would and should be removed from that case. The executive power of the government is not vested in the United States attorney. It's vested in one man, and that man is the President of the United States.
By statute, it's vested in the law enforcement is vested in the Attorney General.
Yes, but that statute, which my brother cites in his brief, does not deprive, nor could it deprive, the President of his constitutional authority to be the chief law enforcement officer. He shall take care to see that the laws are enforced.
Now, finally, there's another exchange involving Mr. St. Clair, and immediately prior to the clip we're going to play, he had been discussing with the bench the relevance of, to this case, of case law that grants immunity to judges and congresspersons under certain circumstances. So they discussed the relevance of those cases, and then they're also going to be discussing the nature of executive privilege and whether it ought to vary in the protection it provides the president depending upon the content of the conversations.
This is pretty far afield from the basic question here, which is the testimonial privilege.
We say it's a constitutional privilege.
Not prosecutorial immunity, but testimonial privilege is what we're dealing with here.
That's correct. I think so. I would want to make the point with you that we think that the privilege we're arguing for is both common law and constitutional.
I understand.
It's constitutional because it's inherent in the executive power.
I understand your argument, but that.
And it's common law
This
because
matter
it's
of
always
whether or not
existed.
they can, a judge can be prosecuted criminally, or
It has to do
has
with
nothing to do
questions
with
of immunity.
testimonial privilege, does it?
Well, my brothers seem to think it does because they say because of the implications of criminality here, the president has lost something he otherwise would not have had.
I understand. May I, since I've already interrupted you, may I
Please do.
prevail upon your good nature a little more, Mr. St. Clair, to ask you whether it is your claim that any of these materials have to do with what have sometimes been called matters of state, i.e., matters of international relations or national defense. Mr. Jaworski assured us that they did not involve matters of state, but I would like to hear what you have to say about that, because, as you well know, both the commentators and court decisions have made a dichotomy between the privilege that exists with respect to ordinary general confidentiality on the one hand of the executive and matters of state on the other, to which a higher privilege has sometimes been thought to be accorded.
Well, I think if a higher privilege has been accorded, it should not, but in any event, the privilege of confidentiality is not unimportant. However, let me direct myself to your question. The answer to your question is no one knows.
But you
won't know until you listen to these tapes as to what subjects are discussed.
Okay, then, Hiroshi, can we get the PowerPoint back up? So this last point on whether there's a sliding scale applicable to executive privilege is one that the court spoke to in U.S. versus Nixon, not squarely, but it recognized a qualified privilege when all the president was claiming was a generalized interest in confidentiality, leaving open whether some different standard would apply when affairs of state and national security interests were on the table. And obviously that question is of some great moment in the circumstances in which we find ourselves today, and may in fact be a matter that will receive some attention in litigation in the very near future. So I wanted to play just this few brief excerpts from what was a 3-hour argument to give you a sense both of the flavor of the position the president was taking, which, although expressed in quaint terminology, we don't call lawyers in court brothers anymore, and before a very different bench. I really enjoyed the part when one of the justices apologizes to Mr. St. Clair for interrupting him and begs his indulgence to ask him one more question. I don't think you'll ever hear any of today's justices apologizing for interrupting a lawyer. The court issued its decision in a little over 2 weeks. It was unanimous. Associate Justice Rehnquist did not participate. It was an 8-0 decision. It answered the question, yes, the Constitution recognizes the claim of executive privilege, which was good news for the president, but no, it's not an absolute privilege, which was bad news under the circumstances for the president. And it held that in this instance, it must give way to the superior claim of another constitutional branch of government, namely the district court and the criminal trial that was proceeding there. It also left many other questions open, many of them being debated today using the basic frameworks, on the one hand, that President Nixon laid out in his letter, and on the other hand, that the special prosecutor defended in his briefs and arguments, which I haven't begged your indulgence to play any parts of this morning. But the entire oral argument, if you're interested in it, is on oye.com, and it does make for a fascinating listen. Well, events quickly came to a head after the court decision. President Nixon, and he was even urged by his own attorney, Mr. St. Clair, to do this, complied with the order of the court. Included in the 43-odd tapes that the special prosecutor had requested was one of a July 23, 1972 conversation, which has become known as the smoking gun, a tape that clearly reveals the president and Bob Haldeman just 4 days after the break-in talking about ways to subvert the CIA and FBI investigations and to cover up the facts of the matter. And in August, the president resigned. Throughout these events, I think we owe a great deal to a federal judge who first addressed all of these grave constitutional issues in his courtroom, and as I said earlier, had the courage of his convictions to render the decisions that he thought called for by the Constitution. Time magazine also thought we owed him a debt of gratitude because John Sirica was Time's Man of the Year in 1973. And so it is a significant gift we're receiving today, and it's my great pleasure to participate in these festivities on behalf of the Public Law Program. And now let me turn the program over to Mr. Sirica.
Thank you very much. I'm honored to be here. It's a great school. My father was a big fan of this school. He was close friends with Ken Pye, who was the dean several generations ago. I, as a professor mentioned, graduated here, though with a little bit of a rough record in 1976. During this period here, I had pulled number 12 in the draft, which we had back then, and school seemed like not such a necessary thing when I might be shipped overseas. And I withdrew passing in my second semester freshman year and went to work at the Washington Star as a copy boy, where on one midnight to 8 shift, the head copy boy, who was 40 years old or so, says, "What are you doing here?" And I said, "I don't know. I dropped out of school." He said, "Is your father going to pay for you to go to that school?" I said, "Yeah." He said, "What are you doing?" And, it took that. And fortunately, my father was patient enough to send me back here. I have just a few personal remarks about Dad and his involvement in the case and also in this letter. I was paging through his book that he wrote after the case was finished, and he had a phrase that went along the lines of, I have to pinch myself to believe I'm really here, and it was his mentality in this fight as well. He'd grown up poor. He was the son of a barber. He and his mother and brother and father were itinerants, basically. When he was a kid, they'd move to Dayton, Ohio, to Los Angeles, to here and there, where his father would try to get started and get on his feet, and it never quite happened. Finally, they end up in Washington in 1918, and there they stay. He loved Washington, and frankly, not to sound corny, he was in love with the idea of being an American citizen and of course a judge later in his career. This case to him was in some fundamental way a police case, especially the burglary trial, where you had people coming into court, burglars. I remember sitting in court one day, and they had been arrested with crisp $100 bills in their suit jackets. And the prosecutors weren't asking the questions, and he said, let me just ask a few questions. He said, "Now, where did this money come from?" And, "Well, Judge, I don't know. We received it." "Well, was it in an envelope?" "Yes, it was in an envelope." "Well, did it have a return address on it?" No, Your Honor, it did not have a return address." Well, did it have a postmark on it? No, sir, it did not have a postmark. I mean, this was the kind of case it was. And, you know, you figured later that the money came from the committee to re-elect the president. In this case here as well, with the letter I'm honored to give to Duke Law School, again, there's a police case element to this. Dad, who had gone to Knight High School, and in the last year in the District of Columbia, you could go to law school straight from high school. He did, and he started at GW, and frankly flunked out of there. He didn't know what he was doing. He told a story. The professor one time called on him and said, "Mr. Sirica, what is the etymology of that word?" And he says to himself, "Etymology? God, I don't even know. I don't even know what etymology means." And he drops out. And he goes to Georgetown, and he gets through, and was with a little more studying under his belt. And he was a criminal defense attorney, a prosecutor in the Hoover administration, and knew the trial courts inside and out. This case comes to him. It's a constitutional case. There's no precedent for a judge ordering a sitting president to turn over evidence. It went back to the most germane precedent was the Aaron Burr treason trial in 1806, where President Jefferson had been subpoenaed. The president eventually turned over the necessary material voluntarily, so no one had ever compelled a sitting president to produce evidence. And my father, with this sort of a background, says to himself, and I remember him telling me, you know, here I am sitting here with this kind of a background, never having gone to college, and I need to decide this case. And I remember his, you know, he had a very good law clerk throughout this period, Todd Christofferson, and they studied. I mean, they went back into constitutional law, back into the precedents, but it was a very, as the whole case was, it was a worrisome time to him, because his great fear was, what if I make a mistake? What if I'm wrong? What if I overstretch here? What if I'm considered to be a grandstander by ordering the president to turn over evidence when in fact I shouldn't? What if I've missed a precedent, et cetera, et cetera? So it was a very, you know, he was torn throughout this thing. These were not easy decisions. And I remember in this case here, at a certain point, he had the grand jury come in just before he issued the order to turn over the tapes. And he polled them all, and they have names from all over the country, you know, ethnic names, they're District of Columbia citizens, and he polls them and he asks them, is there any reason that you see that the president should not turn over the evidence, that the subpoena should not be enforced? And one by one they say, no, Your Honor. And he thinks at that moment, you know, here I'm sitting looking at 12 people from, you know, various walks of life from Washington, D.C., and they're compelling the president to turn over evidence. And as he used to say, what a great country it is. So I'm just pleased to be able to give this to this particular school. It did great things for me. He, as I say, came to give the commencement address when I graduated, even though he'd had a serious heart attack not too long before. The pressure clearly of this case finally worked its way. So I'm just happy to be able to turn it over and wish you luck. Thank you. It's in the original envelope that sat in the safe deposit box in Spring Valley all these years.
Thank you very much.
There you go.
You never know when you're living through an event what its importance might be. I'm old enough, as a few others are in this room, to remember the events that have been talked about today. I started law school in 1972, so these events to 1972, 1973, 1974, while I was in the same position that many of you are in today. We knew it was important, the Watergate break-in, catching the guys, the trials, the tapes, and eventually the hearings, and eventually the impeachment and the resignation. What I think I certainly, even though I was a law student at the time, did not appreciate of the series of events is the significance of what's in this envelope. That is to say, the legal significance of the executive privilege assertion turns out to be one of the real enduring legacies of this period. So I want to thank Jack Sirica for making this gift to us, and thank you all for coming today. I guess the photographers would like me to open the letter, so I will do that now. So first there's a certificate of authenticity from Judge Sirica saying that this letter has been in his possession since he received it. And then a much yellower, older-looking letter. It's a 2-page letter that starts, "Dear Judge Sirica," and I'm putting my fingerprints on it too much, but it is signed Richard Nixon. And we'll there you go. Great. Thank you. Thank you very much. I believe that concludes our program. Thank you all for coming.
Thank you. That was great. Very nicely done.